Hi, I'm Shan Wu with a Under Color of Law question. Gosh, is Donald Trump right about the Constitution for once? He says birthright citizenship is all about slavery, and that's why he's going to win in the Supreme Court, and we're all awaiting the Supreme Court's decision among a slew of other decisions on their kind of backlogged docket. Now, that decision's not here yet, but I wanted to talk with you a little bit about it so that we can all remind ourselves what we're actually watching for in that decision. That's the kind of thing we want to do here on Legal AF, is not only to react to breaking news, which we do a good job of doing, but also taking some deeper dives into issues, not just being reactive. So we hope that you will join us on our mission to make this the biggest and best legal analysis and political analysis channel around. So please hit that subscribe button. Now, let's take a listen to Trump for one moment. I'll talk to you on the other side.
The Supreme Court agreed to hear oral arguments in the case about ending birthright citizenship. How confident are you that the court will rule in your favor and allow that order to end birthright citizenship to go forward?
Well, you're just telling me that for the first time. I am so happy. I think the case has been so misunderstood. That case, birthright citizenship, is about slavery. If you look at the details of it, the signings of it, everything else, that case is all about slavery. And if you view it from that standpoint, people understand it. But for some reason, lawyers don't talk about it, the news doesn't talk about it. That's not about tourists coming in and touching a piece of sand and all of a sudden they're a citizenship. They're a citizen. That is all about slavery. And even look at the dates on which it was signed. It was right at that era, right after the Civil War. And if you look at it that way, the case is an easy case to win. And I hope the lawyers talk about birthright citizenship and slavery, because that's what it was all about. And it was it was meant to be positive. And they use it now instead, not for slavery, they use it for people that come into our country and they walk in and all of a sudden they become citizens and they pay a lot of money to different cartels and others. It's all about slavery, and if you look at it that way, we should win that case.
Now, he is right about one thing in this, okay? The time frame of the 14th Amendment, and really he's trying to talk about the Dred Scott case. It did arise after the Civil War. Notice it's hard for him to even talk about the Civil War, right? It's more like that era, the slavery era. But the actual case that he's talking about before the Supreme Court is not really about birthright citizenship. It's really about the question of nationwide injunctions. Now, if you take a look at mass media, you look at the question being posed to Trump, you look at what he wants to talk about, you wouldn't know that, actually. And really, a better question would be to frame it as, are nationwide injunctions an American birthright? That's the real question presented to the Supreme Court in this birthright citizenship case, is whether or not individual judges, typically district court judges, lower courts, can impose an injunction which has the power to go nationwide. But if you listen to Trump and all the questions, you think that the Supreme Court is going to decide for the first time this question of whether persons born in the U.S. are U.S. citizens or not. I mean, Trump's point, of course, goes with his immigration ideas, is that you can't be a U.S. citizen being born here if your parents weren't here legally. That's kind of where they're going with this. And that's what he's trying to do with, that case, that issue only applied to slaves, which we'll take a deeper dive to explain what his thinking is on that point. But if you're watching mainstream media, you might think this is one of the big decisions we're waiting for, is the Supreme Court's going to decide whether Trump is right about birthright citizenship, and perhaps the question of whether Trump can take it away, because it is in the Constitution, just by decreeing it through an executive order. Now, the legal answer, which I've been asked repeatedly for, and you'll see it asked all the time on TV and other places, is can he do that? And of course, the answer is no, he can't do that. It's the Constitution, not an executive branch agency. So Trump can't just amend the Constitution at will or by writing it on some piece of paper. That's endlessly asked, but that's really not the question before the high court. I mean, I love how Trump says the lawyers don't talk about it this way, meaning it's the context of slavery, like he's the only one brilliant enough to see through the error that the lawyers are making. Well, the reason they don't talk about it that way is because the 14th Amendment doesn't talk about it that way. It doesn't make that distinction. We're only talking about slaves, freed slaves, etc. Nor has the Supreme Court precedent that considered the 14th Amendment scope since it was ratified in 1868. They haven't made that distinction either. If anything, they've made it very clear that it's a very broad effect. Now, notice I used the word ratified, right? The 14th Amendment was ratified. It wasn't decreed by a president. They didn't say we're going to have a 14th Amendment. It wasn't even a law necessarily passed by Congress the way we normally have laws. It was ratified by 28 of 37 states. I mean, it's hard to even imagine that undertaking today, what goes into ratifying a constitutional amendment. But Trump seems to think, oh, I'll just kind of like rewrite this thing with my executive order, which is what he did on day one of his second term. He tries to get rid of birthright citizenship with an executive order. And of course, instantly, because people had been preparing for this for quite some time, he gets hit by just like a multiple slew of lawsuits, all seeking to enjoin his attempt to enforce this order. As usual, he loses in the lower courts. These cases now before the Supreme Court are consolidated from 3 cases in which lower courts stayed his attempt to implement his notion of birthright citizenship. But the case has a question presented, which is really only whether lower court judges can issue nationwide injunctions. That's what the court was taking on. And, of course, they took it on their shadow docket as an emergency hearing, not letting the cases be all litigated all the way up through the proceedings. So this shadow docket case actually had some oral argument. And at the oral argument, the justices, who should be really good, right, at legal analysis, compartmentalizing, focusing narrowly on the questions, they couldn't help themselves. They're like repeatedly wading into the question of birthright citizenship rather than just limiting it to the question of what's the scope of a nationwide injunction. Is that a good or a bad thing to let a court do that? And by falling into that, they really ended up giving some legitimacy to a once fringe conservative theory about why the 14th Amendment only applies to people born here if their parents were already here illegally. Okay, it's complete fringe theory, but they're kind of like falling into that. Now, the actual question, nationwide injunctions, that's a bipartisan controversy, okay? Democrats and Republican administrations don't like nationwide injunctions because they flummox the administration's attempt to do things. So Professor Steve Vladeck will put up a post from him, which is really a great resource to have, reminds us of that. He points out that the Biden Justice Department had filed a certiorari petition to the Supreme Court seeking reversal of a universal injunction, that's a nationwide injunction, against the Department of Education rule entered by the Fifth Circuit. Now, that particular case was not a particularly controversial one, but the government cert petition also asked the justices to take up the question of whether the Court of Appeals erred in ordering the district court to enter preliminary relief on a universal, meaning nationwide basis. Now, that was not as charged ideologically, and yet the High Court, chose not to decide it. So scholars like Vladeck are pointing out, this birthright citizenship case, pretty highly charged underlying issue, probably it's not the best vehicle to answer that universal injunction question here. Now, politicians like to characterize the nationwide injunction as a single judge standing in the way. I mean, Trump likes to say that the judges are activists, etc., but it's basically down to that. They say a single judge is standing in the way. I'd like to challenge the way that that's phrased when the politicians talk about it. It's not a single judge imposing their kind of willy-nilly opinion on things. It's the law, and that's what judges are supposed to do, right? They're supposed to rule on the law. So that already is kind of a mischaracterization, the misframing of what's going on there. But nonetheless, the Supreme Court finds this to be such an urgent issue that they take the issue on emergency appeal, an emergency docket. They do have oral argument, and as I said, they find it to be an irresistibly shiny object to like sort of commingle these questions. Because what's really going on there is they love using the emergency shadow docket, as we've talked about. They can't help but want to come in and put their opinions, have them be the ones deciding things. And to be plain here, the question of birthright citizenship, it can't be any plainer. I mean, the Constitution puts it in plain English. I don't care whether, you're an originalist or not. It's totally clear. It says, quote, we'll put it up for you, as you know it already. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Where is the question in there? I mean, I'll tell you, the kind of out there theory is, if your parents were here illegally, then you aren't subject to the jurisdiction of the United States. Cute, huh? Totally doesn't work, right? Just think about it logically. Well, if you're really not subject to the jurisdiction of the United States, then you're kind of like a diplomat, right? You're a citizen of someplace else. The United States can't do anything to you. They can't arrest you. They can't make you obey their laws. They certainly can't decide whether you are a citizen of their country or not. It's completely illogical as an argument. Now, the cases that arose from the 14th Amendment, or rather, one of the cases which was the cause of it, was Dred Scott, a very famous case, notoriously horrible, racist case by the Supreme Court. And the 14th Amendment, Trump's right on this point, very much arose in this era. Okay, post-Civil War, Southern Reconstruction, a lot of resistance to giving blacks the rights they were entitled to give that a war had been fought over. So he's right, it is arising in that era. Where he's totally wrong, of course, is after the 14th Amendment, which failed to make the distinction that he's making, although it had the effect of helping blacks get the rights they deserve to have, the Supreme Court made it abundantly clear it did not apply only to slavery, but to all persons. They were forced, actually, to keep specifying that. 127-year-old case, Wong Kim Ark, Chinese man who brought this case, made it clear that it applied to him. He had trouble getting back into the country after going back to visit family in China. This kind of mischaracterization, simplistic notions of history ignores all the effort that happened over a century ago. There were pioneers, just like the pioneers in the civil rights era in the 60s. In that period, Chinese Americans filed more than 10,000 lawsuits challenging discriminatory laws and practices. That's according to the National Park Service. And those paved the way legally, ultimately, for that victory by Wong to establish that right to birthright citizenship 127 years ago. Nevertheless, at oral argument, the justice has a hard time staying focused on just the injunction question. And they kept diving into questions about, if Trump's interpretation is right, what would happen? How would this work? Now, Chief Justice Roberts mused about how, we don't need the nationwide injunctions because we, the Supreme Court, can move pretty fast like we did in the TikTok case. That's one of his questions. Okay, he seems really pleased with himself that he can use the word TikTok in a sentence. Maybe he feels very hip about that. And the problem there is, wow, what a glacial pace, right? I mean, they move fast. He says, we think we did TikTok in a month. Okay, they got it in a month. They had to decide in a month. I mean, 2 months. The reason you need an injunction is because there's irreparable harm. Birthright citizenship, irreparable harm to all these children being born that are now not U.S. citizens. You can't wait months for the court to figure that out. And they also, of course, ignored the fact that this whole notion that Trump's pushing on the birthright citizenship only applying if the parents are legally here, who's the main proponent of that? John Eastman. Remember John Eastman? This John Eastman, the one the California judge has formally recommended that he be disbarred for his other legal theories that tried to help Trump remain in power after 2020. So it's kind of all about the court's power, right? That's what we should keep our eyes on. Rather than letting the status quo be frozen by an injunction while the issue gets fully litigated like we've talked about before, litigated, fact findings, fully appellate briefed, appellate decisions, they just want to jump in. So how will this resolve? What is SCOTUS going to do? I would say, prediction here is speculation, if they're looking for a vehicle here to deal with nationwide injunctions, I actually think this is not a bad one to them. They're going to like it because they can say, wow, the underlying issue, maybe it's 9-0. No question, 14th Amendment controls, this is not an issue. And for something like this, maybe we will allow nationwide injunctions. We need to have some sort of filter for just how important it might be. So you might get a 9-0 decision here with a whole bunch of concurrences maybe explaining their ideas of how you use the nationwide injunction. And that's going to lay the groundwork, because this is how the Supreme Court precedent works, for future cases that may give more specific guidance as to what's happening. So we'll keep an eye on that. We'll see if my prediction is anywhere in the ballpark at all. And we will talk to you soon. Keep those comments and replies coming. Can't get to all of them, but it means a lot to me, and it's really, really helpful for us too. So talk to you soon.
I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.